which one to choose, which way to go. How can I tell? How will I know? Out of oh, so many stars, so many stars.
Every time you're near a rose, aren't you glad that you got a nose? And if the dawn is fresh with dew, aren't you glad you're you? When a meadowlark appears, aren't you glad you've got two ears? And if your heart is singing too, be glad you're you. You can see a summer sky and touch a friendly hand, maybe taste an apple pie. Pardon my grammar, but ain't life grand? And when you awake each morn, be glad that you were born. Think what you've got the whole day through. Aren't you glad you're you? You can see a summer sky and touch a friendly hand, maybe taste an apple pie. Pardon my grammar, pardon my grammar, but ain't life grand? And when you wake up each morn, be glad that you were born. Think what you've got the whole day through. Aren't you glad you're you? Now aren't you glad you're
a grape, crush me some ice, peel me a peach, save the fuzz for my pillow, start me a smoke, talk to me nice. You gotta wine me and dine me, don't try and fool me, bejewel me.
Good morning. My name is Susan Reardon. I'm the staff hearing officer, and I call the meeting of Wednesday, November 4th to order. Today we have 6 items on our agenda. The last one, item F, which is 1660 Shoreline Drive, has been continued to the next meeting. So if you're here for that, we won't be discussing it. Is there any other changes to the agenda?
There are none.
Okay. I'm not aware of any announcements or appeals. There's none? Okay. Is there anybody in the audience who would like to address the staff hearing officer on items not on the agenda today? No? Seeing no one, we'll go to the first item, which is 1565 Franceschi Road. If the applicant would like to come up. Good morning.
Hi. Good morning.
Need to slide that in the center of the screen. Thanks. We'll use those pictures too. Thank you. Okay, the project site located up on Franceschi Road is about a ½ acre. Zoned A1. It's currently developed on site. This is the shape of the property. Current development on site is a driveway here, the 3-car garage, and the residence here. Project site is under a major remodel and is a part of the improvements. The new property owners would like to add little wing walls off the side of the existing entry gate pillars. I think the best way to show you what's going on is to review the photos, which show the existing situation. Here's the existing entry gate off of Franceschi Road, and a doctored photo here that shows what it'll look like after the wing walls are installed. Staff has been out to the site with transportation planning staff and has determined that although these sections exceed 3.5 feet within 10 feet of a front lot line, there are no safety issues associated with obstruction of visibility with the proposed wing wall. Staff is asking, therefore, for support of the project as it's submitted.
So transportation staff has gone out to the site.
Yes, we have.
Do they have concerns regarding the existing vegetation between the pole in front of this area?
Because of the angle that you actually enter the the driveway at, we were able to pull in and exit the driveway with clear visibility. The right-of-way is extremely narrow,
Yeah.
so those exiting the driveway are accustomed to proceeding with caution. We did not feel that the vegetation, as the car was in this position, obstructed the visibility of vehicles coming down Franceschi Road.
Okay, because that's the way I came into the site. I came down this way, and there was trucks and stuff all over. And I was just wondering about the visibility of exiting. So they put that up. All right. If you'd want to state your name for the record and association and add any other comments.
Kirk Radine, Banyan Architects. I'm the architect for the owner. I think that was a very clear, well-articulated explanation. And I think as Roxanne was saying, that the fact that you can pull completely off of Franceschi Road into the space in front of the gates without any obstruction due to either the planting or this new wall is the reason why this seems like it's an acceptable modification. That's all I have to add.
Okay, great. Thank you.
Sure.
I'd like to open the public hearing part of this item. Is there anybody here who would like to address the staff hearing officer on 1565 Franceschi Road? No? I think we did receive a letter from Paula.
I'm sorry, thank you. Yes, we did.
Westbury? She... I think it's in opposition to the proposed wing wall. So I'll close the public hearing. Like I said, I went out to the site and drove around the neighborhood, tried to get an idea of whether it'd be a safety impact, and I agree. It's not a safety impact, and it enhances the gate there. So I make the findings, outline the staff report. Originally, I was thinking of adding a condition because of the visibility, requesting transportation staff to go out and look at it, because I wasn't clear reading the report whether they actually went out for the site visit. So since council has temporarily suspended the enforcement of hedges, and this one doesn't pose a safety issue, I'm no longer going to suggest that condition. So approved as submitted.
Thank you.
And there's a 10-day appeal period, and the Planning Commission has oversight of all my actions, and they could decide to call it up for a hearing before them. If that were to occur, Ms. Malazzo would contact you.
All right.
Right?
Thanks very much.
Sure. The next item is 256 San Nicolas. If the applicant would like to come up. You can have mine, too.
Thank you.
If you need it.
Good morning.
Good morning.
I have a flat copy if that helps.
You know what? I'm going to use mine because it's been doctored for the viewing audience.
And anytime you're ready.
Thank you very much. Okay, this project site, just over 6,000 square feet, is located up in the Mesa neighborhood on the corner of San Nicolas and San Miguel Streets. Current development on site consists of a single-family residence with a carport here accessed off of San Nicolas. The proposed project involves an existing fence located here along the front lot line. The zoning ordinance limits the height of fences to 3.5 feet when located within the first 10 feet of a property line or within 10 feet of either side of a driveway. This photograph shows the existing situation, which allows this property owner to secure privacy to her rear yard area. We understand that when there are corner properties, they have a recognized constraint with securing privacy out on backyard that those with not corner sites don't have to deal with. Staff routinely supports these type of modifications when we can make the finding that there are no visibility or safety issues associated with the height of the fence on the property line. Staff is asking for approval of this fence as it currently exists. It has been seen by the Single Family Design Board. They too think it's compatible with fences, as the other photographs show, on various corner lots throughout the Mesa neighborhood, particularly on San Miguel, where almost every corner lot has the overheight fence for the purpose of securing the privacy to their rear living areas.
And the overheight fence just extends for the backyard, it's not along the front property line?
That is correct.
Just the 44 feet here at the rear of the back property line.
Okay. All right, if you'd like to state your name for the record and add any other information?
I'm the owner, Inga Rose. I think Roxanne stated it well. There have been several zoning reports on the lot when it was purchased in 89 and again in 92, and in neither case was this called out as a non-conforming or a problem in any case. Transportation has been out to review any problems, and they did not have a problem with anything on the site.
All right.
I'd be glad to answer any questions. I think the zoning report and the staff report stated everything well.
Okay, great, thank you. I'd like to open the public hearing for 256 San Nicolas Avenue. Is there anyone here who would like to address the staff hearing officer on this item? No? We received a letter, again, from Ms. Paula Westbury on this project. I guess it's against the project. So this fence was already removed. It was great. Yeah, okay. So it's against the fence. So I'll close the public hearing. I went out to the site and traveled around the neighborhood. It's hard to know which fences are actually legal and which were just constructed with the development of the neighborhood and the houses. I agree. Typically, in this type of situation, you do see a fence along the secondary front property line to secure the backyard area. My concern regarding this project is the cumulative effect with the fence, including the hedge coming all the way around. And I know the hedge was not found to be a safety violation, but it is still in violation of the zoning ordinance. And the City Council, little over a year ago, or maybe about a year ago, temporarily suspended the enforcement of hedges on the front property line. And that's what I think Betsy, Ms. Teeter, and the transportation staff was referring to, and that is not a violation in terms of safety hazard, but it still is a violation of the zoning ordinance, in which they won't enforce at this time. I could support the fence, and does the fence, what's behind the hedge here? I know that you have a gate in this area. Mm-hmm. Is there a fence behind this hedge here? Or is it?
It's just a netted, just netting, metal netting.
Okay. I could support the request for the fence, and then although it wasn't outlined in the notice, it was described in the notice of a fence-type structure to secure the backyard, to have from this area here to the front of the house here, have this exceed the 3.5 feet height, up to the, what's it noted as, 8?
Well, it's a 4-foot fence on a rock wall that's, as the cornerstone shows right here, that photograph, that wall's been there over, it was built in 1975.
Yes.
Or corrected in
It shows that
75.
it's 66 inches.
Okay, so yeah, that's what my question, is this height, the total height of the two?
The total height of the two is shown
Right here?
At the highest point,
7.1.
it's 7.1. At the lowest point, it is 6.3.
Okay.
Because this slopes downhill. The fence itself is only 4 feet at any time.
Okay.
Also, these are both zoning reports that the city put out, and neither in 89 or in 92 was there a zoning violation with this existing fence.
Okay. Well, what I'm saying to you is that I can support from here to here, this to exceed the height, so exceed the height limit of 3.5 feet. But the hedge, the cumulative of having this go all the way around, I don't believe that's consistent with the zoning ordinance or an appropriate improvement. So with approving this, I would condition that this portion be reduced to 3.5 feet in height.
I thought that I was here today only with regards to the fence, because this part had already been taken out of the equation at
What-
this point.
Mhm, and what-
So, and I thought single family also reviewed that and took it out of the equation, and the transportation took it out of the equation.
What I'm telling you is that what I was trying to explain is the part that's taken out of the equation is that it was found not to be a safety violation. So under council's action to suspend enforcement on overhead hedge heights, they suspended the enforcement of it. And unless it's determined to be a safety hazard. And transportation staff has gone out there and said it's not a safety hazard.
Right, that's correct.
Okay, so you're asking for a modification to allow the fence to exceed 3.5 feet in the front setback. And what my finding is that that modification is consistent with the purposes and intent of the zoning ordinance, and it's an appropriate improvement. And what I'm telling you is when I look at the cumulative, when I look at your property specific, and I look at your fence and the hedge, I don't believe the combination of that is consistent or appropriate improvement going in front of the house, because this is still your whole front yard, although this is termed a primary front yard and this is termed a secondary front yard. It's still your front yard. And so the provisions still apply. And so for me to be able to make the finding that this portion of the fence is an appropriate improvement, given the sum total, I think to be able to make that, this portion of the hedge, which I know no modification was requested today, but when the idea of the suspension, I'll go back again, the idea of the suspension is during that 2-year period, we'd work on an amendment to the hedge ordinance, and I don't know what that amendment would be. Would it be, would not even regulate hedges in the front yard, whether it would specify they need to be a certain height or what? We don't know, but that was the intent of that suspension part.
But this has also been there since before 87.
1956 is the cutoff for it to be determined non-conforming. And if you can show it was planted before then it is non-conforming and my condition would not apply.
Okay. I was not prepared to talk about the hedge because that was, as I understood the process to date, had already been taken out of the equation. When I provided these plans, I also provided a set with photographs showing the condition of the
Yes.
Marine Terrace neighborhood. I have a flat one if you want me to roll it out, or
No,
this
yeah,
one
and
here.
I looked at that, and like I said, I drove around the neighborhood, and I don't see any other hedges exceeding 3.5 feet on a corner lot that, in that area.
These are examples within Marine Terrace, just Marine Terrace. I have not gone outside of Marine Terrace. If I went outside the city, outside Marine Terrace, there are many examples I could show, but there are hedges, in fact, fences
There's one
even.
right here. This hedge goes along here. It's 3.5 feet. I didn't see any other, or it's down in this one. It's one of these two. I didn't see any other hedges.
There is a fence, actually, that goes around.
Okay.
This one goes up.
Okay. What I'm telling,
This, I believe...
this one's yours.
This one over here is mine down at this end, but this one goes to the street.
And then it cuts down.
Upside down, I'm having a problem.
Well, what I'm telling you is I can support your fence,
Okay.
but with the condition that the hedge, that,
So if I provide old photographs,
yes, you can work with Ms. Milazzo in determining whether it's non-conforming or not, and then that condition would not apply. But for me to be able to make the findings, and I could even include this portion up to the front of the house where this gate is, because this secures your backyard. Here's
Right.
your backyard. It's just this area from the front of the house around the corner that when I look at the sum of the whole improvement there, I can't make that finding that it is an appropriate improvement. So what I can do is I can approve that portion with the condition, or I can just deny the whole thing and you can appeal it to the Planning Commission. And you can even appeal the approval with the condition to the Planning Commission. All my actions are appealable to the Planning Commission. So I don't know which way you want me to go with the approval and the condition.
well, I'd like to get this approved.
Okay.
It's frankly a hardship, the whole process already. And I'll have to see if I can find historic photographs for
And you
that.
can work with Ms. Milazzo and even Ms. Brooke, who's the zoning supervisor, who works a lot with people with hedges. Either of them could be real helpful.
So this part of the hedge is only with historic photographs or an appeal?
I would talk with Ms. Milazzo
Right.
after
We'll
the
discuss that.
hearing.
You can give me a call maybe after 11 this morning. I'll explain what those options are. But I would suggest you take an approval
Yeah,
of,
I
with
will.
the conditions today, and then
I
we'll
will.
decide
Okay.
how you'll deal with it.
Okay, so I approve the project of the fence and hedge combination, Gloria, up to the front face of the building, of the existing house, and then the hedge from that point around, not to exceed 3.5 feet in height.
And I would assume that you were talking about the 20-foot setback line. Because a house is set back further than the 20-foot setback line.
Well, this, right here. I'm saying from this part here.
Okay.
So from the
Because the house
existing-
in this case is set back further than the required 20-foot front setback.
Yeah, so I'm just talking along the front property line and with this existing fence that's here. So just this area up in here.
Reducing only this section to 3.5. The rest she's approving as it exists.
To the maximum 8 feet in there.
8 feet? Okay.
All right, so like I said, my action is appealable within 10 calendar days. The Planning Commission also has oversight authority of all my actions, and if they decide during that same 10-day appeal period that it warrants additional discussion, they have the ability to call it up for them too. Okay?
Okay.
All right?
Thank you.
Yeah.
Thanks.
The next item is 1600 Mountain Drive. If the applicant would like to come up to the table.
Thank you very much. Just spread that out there. Okay. This project site is over 18 acres, located up on West Mountain Drive. The dark green line shows the configuration of the lot. Current development on site are some accessory structures that have been approved through a modification process in the past. The previously existing residence was destroyed by the T-fire. Its three-car garage survived the fire and is still existing in this location. The property owner has been in our process proposing a single-family residence in this area of the site. It's going through the design review process currently. What is before the staff hearing officer today is a request for a performance standard permit. It's a provision in the municipal code which allows for additional dwelling units if a lot area can accommodate, including its slope density, accommodate multiple units, and as long as adequate egress and ingress is provided. The proposed project, which now involves the rebuilding of the destroyed home, does comply with the minimum lot areas and the access and egress requirements as identified for the performance permit approval. And we are asking today for staff to recognize that the project does qualify under the criteria. Your approval would allow for the development of 2 single-family residences with their associated accessory space and garage space, developed just as though it were 2 separate lots, but no subdivision being proposed. Staff position is that the project does qualify for the approval and is asking for approval of the project as submitted.
Great, thank you. Do you like to state your name for the record? And
Ted
add-
Gardner. And what else?
And do you have anything else to add?
No, she did beautifully. I don't even know why I'm here.
Okay. Great, thanks. I'd like to open the public hearing. Is there anybody here who would like to address the staff hearing officer on 1600 West Mountain Drive? Oh, there is actually, sorry. Jeff Johnson. If you'd like to have a seat, you know, seat.
I didn't come here to talk about this. This is.
Wow.
Yeah, I just I was more interested in his roof line on this new construction, but we talked about that last time. So this, if it's just about the 2 buildings, it's this is premature for me to talk about any of it. So.
Okay, yeah, the design, actual design of the house would be going through the single-family design board under
And
that
that's
time.
later on.
Yeah,
Yeah,
I
right on.
think it
Right.
might have gone for
Well,
comments.
this one's gone. This one's in process. Yeah. Well, he was here for that.
Yeah, I talked about the piano on the roof, and if there's no more discussion on the new proposed house, is that in the future?
That house,
This one.
this one has already come before. This house has received a modification for an enlarged carport.
Yeah, yeah.
And so it's already been before the staff hearing officer. I don't know what process it's at the single-family design board,
Have
how
we
far
talked
it's
about signage on that house yet, like words and stuff written on?
That would be the
signage?
single-family design board.
And that's later.
Yeah.
Yeah, right.
So if you're on the mailing list, the notice, public notice for this
Yeah.
one, then you'll be
Super.
noticed.
You want to put Johnson Plumbing on there?
Yeah, that's what I was going to say.
All right, great, thank you. Is there anybody else who would like to address the staff hearing officer on this item? No, I received a letter from Ms. Paula Westbury stating that this was not a T-fire house opposed to the project.
It's not a T-fire house? What was it? I wish I had known that.
Oh, here's the applicant copy. This must be the one. Okay, so I'll close the public hearing. I've been out to the site a couple times with the original request for the new house. And at that time, I know also in the staff report it talks about a condition that was proposed
Oh, yes, thank you.
included for this house that the garage be converted to storage and not used as garage, and that is part of the request now to be able to use that as garage. I think this lot is more than adequate to accommodate the houses and the associated accessory structures. It's over 18 acres. I think it is an appropriate request. I would, though, condition the project to specify a snapshot in time what is approved now. And so as a condition of the approval, it would just specify that the development on the property is limited to the 2 single-family residences, and then also call out a total of 1,538 square feet of accessory space, which is these 2 buildings combined, as well as the 782 square foot garage, and the proposed 872 square foot carport for this house. And so,
Probably not going to rebuild this, so that'll be taken off. It'll be a swimming pool. Yeah.
okay. Was this one?
There's a swimming pool, and there was a
Swimming pool
cover.
enclosure that had received a previous modification.
Yeah.
Correct. Okay. Well, this is just specifying it at this point in time what was
So
reviewed as this
you're telling me
application.
I can't put a Hilton Hotel down here? Is that the idea?
No,
This is it?
Yeah, this approval does not cover that.
I'm not going to live that long anyway.
Yeah. Yeah, so I make the findings outlined in the staff report and approve the project, which includes the performance standard permit for the 2 dwelling units, as well as amend the condition for the previous resolution that required this garage to be converted to accessory space. Okay, so my action is appealable to I amended the...
We can use it
yes,
as a
the
garage.
yes.
Ah.
Yeah, so I removed that condition that required this to be converted to
There's no
accessory.
room in it now. We got everything.
Okay, so my action is appealable to the Planning Commission within 10 calendar days. And they also have...
I mean, you want me to? Yeah.
No, if you want to, you
I
can.
like it.
If
Somebody else shows up.
yeah, if a concerned party wishes to appeal it, they have 10 days. And then also they have oversight authority, like I said in the previous applications, of all my actions. And they can decide whether it warrants additional discussion before then. And if either of those two events were to occur, Ms. Malazzo would contact you. Okay?
So are we home free in 10 days if nobody makes a fuss?
The modification part is, yes, would be approved, and you would continue on with the single-family design board. You don't have to wait. Yeah, you don't have to wait the full 10 days to apply to get back on the SFDB agenda, but it would be proceeding at your own risk. But no one showed up here. So.
That's no problem.
Okay, great.
Thanks
Thank you.
very much. Appreciate it. Good to see you again.
The next item is 306 Sherman Road. The applicant would like to come up.
Thank you.
Those are yours too.
Thank you. The applicant.
Morning.
Good morning.
Morning.
Morning. Anytime.
Project site, just a little over 16,000 square feet, was one of the properties where the previously existing structures were destroyed by the T fire.
If I may correct, it's 10,500 square feet.
Thank you. Okay, do you have an idea where this figure came from?
That came from city records, but doing a calculation, it comes out as
Maybe net versus gross, or?
potentially.
Okay, thank you. We'll make that adjustment. Okay, so the lot is currently vacant. Proposed development is for 3-story single-family residence here with a garage and access off Sherman Road. The discretionary application being requested for the project is a modification to allow the garage portion of the proposed development to be located within the required 35-foot front yard setback. The project has been designed in pretty much the same footprint that previously existed, but in order to improve access into the required parking area, the applicant is asking to pull the garage forward into that front yard setback. We wanted to point out that the rest of the lots on the street going east received a blanket approval at the time of the original subdivision, giving them smaller front yard setbacks. Taken into consideration at that time were the narrowness of the lots, the undersized lots. In these A1 zones with these 41% slopes, you would need 3-acre minimums. And the steep topography in this rear area, which forces the development up to the front portion of the street. Staff is supporting this request as we have on several of the other homes on Sherman Road. It's a consistent pattern of development to provide a smaller front yard. And again, it's just for the parking. The rest of the development has been proposed to observe all current zoning requirements.
Now, Ms. Milazzo, what, the blanket modification, did it call out a setback, or did it say, like, as shown on the plan, or do you know?
Actually, I have a copy of it here. It was for 10 feet for 4 of the parcels and 15 for 1.
Okay. So it would require 10 feet versus encroach 10 feet? Mm-hmm. Yes, okay. All right, great, thank you. All right, would you like to state your name for the record and add anything?
Yes, my name is Hector Magnus. I'm with Architects Magnus. I'm the project architect. And I'd like to say a few things about this. For starters, is that allowing a modification of this nature would give us the opportunity to be consistent with the rest of the development down Sherman Road. It gives us also the opportunity to put a garage in the front yard setback, and only the garage, in this case, is what we're asking the modification for, not the entire buildable area. It gives us the ability to also have an easier access. And as Sherman Road is not a through street, it also allows for parking in front of this garage, as there's no improvements with sidewalks or anything else. So we've had some good comments and support from the neighborhood, from most of the people on Sherman Road, and we're very happy to provide this project before you.
Okay. Just one comment on your comments. Parking's not allowed in a front yard setback unless it's screened from the public right-of-way.
Correct.
Just the comment about parking in front of the garage.
Yes, ma'am.
Okay. Would you like to state your name and add anything?
Antara Dayal.
So you're the property
I'm
owner?
the owner.
Okay. Did you have any, you want to add any comments, or just here to listen?
Yeah, well, just keep going, Hector.
Okay, great, thank you. I'd like to open the public hearing. I do have one request to speak from Nellie Slack. Who can have a seat right here and use that microphone?
Hi.
Good morning. My name is Nell Slack. I live directly next to Antar at 312 Sherman Road, and I would strongly support the modification of the setback, as has been stated both by Ms. Milazzo and Hector. It does stay consistent with the rest of the neighborhood, and we do not see any issues with approving this modification.
Okay, great, thank you. Is there anybody else who would?
Yes.
Turned in 2 slips.
Oh, sorry.
Thank you.
So, Tony, you would like to go first?
Yes, please.
Okay, this will be Tony Fisher, followed by Hazel Anderson.
Yes.
Thank you, and good morning.
Good morning.
I would also point out, I think there was another neighbor going to be here, but you're ahead of schedule from what we anticipated.
Okay.
My name is Tony Fisher, and I'm here on behalf of Hazel Anderson. I actually got involved in this matter as of yesterday, but I have taken the opportunity to prepare a one-page list of items of considerations I have copies for people present. I've had a chance to look at the staff report. I've had a chance to look at the drawings. I did ask last night that the drawings that were submitted to the Single Family Design Board be brought to you, because I think they might be a little clearer in terms of displaying the project as it is before you. I think there's some color on them, and we were having trouble reading those drawings. Let me say that the initial concern my client has, and there hasn't been any contact, she lives adjacent to the property on the large lot that is immediately downhill. And she was not at the Single Family Design Board because she didn't get notice of that. And secondly, when I look at the notice, it doesn't really tell you the extent of the intrusion into the front yard that is taking place. As you can see, the entire garage is in the required front yard. My list of items that I've brought to your attention, this one is a bit different than the other houses on the lot, which received a waiver or modification in 1976. As you would know, in 1976, the standards were different than they are now. We didn't have a single-family design board. We didn't have the concern. Besides that, this property has existed for many years with a house and a two-car garage outside the required front yard. If the standard is being applied that if it is possible to build without going into a required front yard, this site has demonstrated for many years that it was possible to have a two-car garage with reasonable access without violating the front yard. I also believe that from the drawing, it looks like the garage is now within 15 feet of the street, which is, I believe, closer than we allow any garage to be to a street, because it would prohibit being able to park temporarily in front of the garage without extending into the street. This is a dead-end type street, which actually only the next property is my client. I have listed here the single-family design guidelines that in a quick review of the drawings, it appears that this set of plans would violate. And as you can see, I have listed 7. The apparent height, and this design is allowing for additional size to the project. I don't think I've ever gotten involved in a fire rebuild case, particularly if they're staying within the footprint. This one is not staying within the footprint, because I understand the concerns. In fact, my client's house was burned down too, and she recently has gotten approval for her reconstruction. Would note she was required to come up with a landscape plan. This one does not. We don't see a landscape plan, and there is extensive glass uphill of her property, which means her night sky is gone. It'll be that entire side of her property will be lit. I know this went to the Single Family Design Board, but it actually went to the consent agenda. I don't know why, when you're extending the footprint and asking for a modification, that it would go to the consent agenda, which is only one member of the Single Family Design Board. I don't know what was said there. I don't know what was presented. I don't know the rationale, and there is no tape. So it isn't possible to go back and recreate and I did see that there are some comments that question the extensive amount of glazing, which is a concern. So I don't think there's a basis to make the findings to grant this front yard setback. I would invite the applicant to sit down with my client. That has not happened. To talk about this project and before it goes further. I would invite that all of these policies and procedures be looked at more closely, and that this project not receive an approval from the staff hearing officer. Now, Hazel Anderson is here. She also, I think, has a few additional comments. She has lived there for many years and really sees how this would impact her lifestyle.
Okay, great. Thank you.
Thank you.
Sanderson, if you'd like to come up and provide your comments.
My name is Hazel Anderson. I live down below this project, adjacent to it, but below it. So the impact of this project is enormous on my home. My only flat recreational area is below this home. So that if you were to look at my plans in juxtaposition to this house, you would see the enormous impact this is going to have on me with 3 stories and this amount of glass and the additional verandas or whatever decks going around the house. That is the area where I've always had a jacuzzi, barbecue area. It's my only place of recreation, even though I have a 2-acre lot. The house, the property next to me also has a steep lot behind. There was never any planting or irrigation in place there, and it will have a huge impact on my home, because we had 3 layers of vegetation, which is gone. My husband passed away the year before the tea fire, but he had planted eucalyptus trees, and then we'd have I think it's Myosperm, the tall, and then in front of that oleander, and then lantana and etc. down, so that we had tried to screen as much as we could from that home because we were there ahead of it. We were never told, we were never given the plans prior to it being built. It just suddenly was being built. On this occasion, I haven't been contacted by anybody. I got a letter and responded, and in fact came down because I wrote, and then I thought about it and thought, well, this is extraordinary because it will impact me so enormously. I can't tell you how enormous the impact is. It isn't a little bit. But to suddenly look up, and I'm way down below, I'm probably from the corner opposing the garage where he's planned to put a 6-foot wall, I'm probably at least 15 feet below where my house is because of the steep terrain at the north side of the property.
Yeah, I went
It
out to the
slopes
site
down.
and I looked.
So
yeah,
you understand
down.
what I'm talking about.
I saw down there.
So those windows look directly into my living room, into my bathroom. It just has this huge impact. I have my plans outside. I mean, you can see the impact that it has on me. It's an enormous impact. And it's taking up, I mean, its appearance will be far more than what the property appears to be on paper because it's really going to fill that space. And then putting the wall around, it's going to be a block, a huge mass that's above me, that towers above me. So I would ask you to really rethink this one because it's enormous. The night sky is gone. It just impacts me tremendously. Okay, thank
Great,
you.
Thank you. Is there anybody else who would like to address the staff hearing officer on this item on 306 Sherman Road?
Dr. Dinning is going to come. He's below. He's around 10 o'clock, as what I thought the time would be. But he's the house immediately below this house, and they have not been contacted. And they're even more impacted because they sit, like, the lock comes down there and they're behind that lock.
And when you say they haven't been contacted, you did receive legal notice prior to the project appearing.
Well, no, I mean, I spoke to him about the time frame is what I'm talking to you
Okay.
about. Okay, thanks.
All right, I did receive, did we get a letter from Paula Westbury on this one?
I believe so.
Oh,
Yeah,
you
it should be
are
in here.
Okay. Yeah, these are the same. I received 5 letters for this project. One is from Ms. Anderson, opposed to the project, and 3 in support of the modification, stating the fact that this modification would allow for similar setbacks as the other properties on the lot, on the street. And then also another letter from Paula Westbury against the project. Roxanne, would you like to explain just briefly about what we've done with the T-fire rebuilds and the single-family design consent calendaring noticing?
Right, in an effort to expedite these applications, we are seeing them on consent. We do notify the neighbors within distances of the development so that they can come in, look at the plans, and make comments. I want to keep the focus of this hearing, though, on the encroachment being requested for the garage. The design of the house, the glazing where the windows look, and the walls should really be taken up at the single-family design board. This project does need to go back for a final approval with opposition. I mean, could we condition any modification approval that it goes back to a full board?
I'm not sure about that. Anything about that? But yeah,
We encourage the applicant to work with the neighbor to try to mitigate through design any possible impacts associated with the proposed development.
And of course, we'd be happy to work through these items. Again, as I look at the modification request before you, it is on the opposite side of her property, of Miss Anderson's property, which is less impact than if the garage request or modification request was on the west side of the property.
my purview here today is on zoning, consistency and relief of zoning standards, and what they've asked for is a modification of the front setback. The house itself is conforming to the required setback areas. That's providing 15 feet on each side, and it's also within the 30-foot height limit, so that and complies with the solar.
Not from where I live.
From the natural grade, and they do have the 1,250 square foot open yard area. It's in the rear of the site, and so what they're asking for is relief of the front setback to allow the garage to be located 15 feet from the front property line. And I understand your concerns greatly. The Good Neighbor, the Single Family Design Board has the Good Neighbor policies that look at glazing. It looks at window placement in relation to neighboring properties, providing screening to increase privacy to the two neighbors. So I understand your concerns. The house portion, though, is not before me today, and so
I understand that the modification would allow that house portion to go ahead.
I've closed the public hearing, but the house could go forward even without a modification. They could put the building back. I think given this property, the size of the property, the zone is A1, which requires 1 acre minimum, and the size of the lot is significantly less than that. It's 10,000 square feet. The slope of the lot, it's 41%. And when I went out to the site, you can look and you can walk on the building pad, and past the end of the building pad, that the lot steeps down. We don't want development down there. So in terms of the appropriateness of addition to the house and the location of the house, this is the appropriate spot for the addition towards the front. And just because if the modification were not granted, they could propose to move the whole house down and go into the sloped area, which would not be appropriate. So I think given the constraints of the lot, the size, the substandard size, the slope of the lot, as well as the existing development pattern along the street, that those are all justifications and reasons why you could support the modification. That the setbacks for the other homes range from 10 to 15 feet. They're proposing 15 feet for the garage. And that the house is set back 35 feet, which is required. So given those facts, I can make findings. I'm going to change the proposed findings that are in the staff report to clearly state what the justifications are, and that how I propose to change them is that the staff hearing officer finds that the modification, and then add to allow the garage within the front setback, is consistent with the purposes and intent of the zoning ordinance and is necessary to secure an appropriate improvement on the lot. And then I'm going to add the existing lot is located at the end of the cul-de-sac and is constrained due to the existing slope of the lot and the substandard size and size. So it's the existing lot is located at the end of the cul-de-sac and is constrained due to the existing slope and substandard size of the lot. The reduced front setback allows for the replacement garage to be placed on the less steep portion of the lot. The proposed front setback is compatible with the development pattern of the street. And that, I think, reflects all the justifications for the modification. I'm not proposing any conditions with this. Staff wasn't either, right? So I approve your project, making those revised findings. My action is appealable to the Planning Commission within 10 calendar days, and that's filed here at the planning counter versus City Hall. They also have oversight authority of all my actions, and they can, if they decide this warrants additional discussion before them, they could call it up. I would highly recommend that you meet with your neighbors and discuss their concerns prior to going back to the Single Family Design Board, because it's good to work with them, and also they will take their considerations and comments into their deliberations.
Understood.
Okay?
Yeah.
Thank you.
Thank you.
Thank you.
The next project is 302 East Haley Street, if the applicant would like to come up. Morning.
Morning.
Anytime you're ready.
The proposal today is the operation of a medicinal cannabis dispensary within an existing commercial space at 302 East Haley. This dispensary will occupy 2 existing commercial spaces totaling 1,800 square feet. The property is a CM zoned lot and is located within the mixed-use development at the southeast corner of the intersection of Haley and Garden Streets. The C2 zone is considered a commercial zone. I'm sorry, the CM zone is considered a commercial zone, and this proposed location is more than 500 feet from the nearest dispensary and more than 500 feet from any school or park. Therefore, this location is not prohibited by the provisions of the code or any local or state law, statute, rule, or regulation. As illustrated in the staff report, the applicant has submitted the operational plan that details how the business would be operated to comply with Chapter 2880 of the zoning ordinance. With regard to security, there would be 15 cameras set up to monitor the inside and entrance points of the dispensary and help ensure no loitering, nuisances, or criminal activity occur in and around the building. The dispensary will be separate and secure from the reception and screening area, and will be additional security measures will include bars on the doors and windows, and the windows along Garden and Haley, the corner of the building here, will have to remain clear and unobstructed in order to maintain a storefront that is visible from the street and the sidewalk. So just to clarify, when you walk in, here's the corner of Garden and Haley. The main entrance will be here, and it's divided by this divider wall. And this side of the building is the screening and reception area. This side of the building will be the separate and secure dispensary area.
And the bars go on the dispensary side, not on the lobby?
Correct. The bars these windows here will be required to remain clear and visible from the street. On this side, they want additional security measures as far as security bars here and here, back, to prevent entrance and exit. And also, I think it's called alarm glass, where if it is cracked or damaged in any way, the alarm will go off. That's a condition of the police department. I think that was mentioned at the site visit also. So the proposed plans have been routed to Captain Armando Martel of the Santa Barbara Police Department, who also conducted a site visit. Captain Martel found that this proposal is consistent with the municipal code and stated that this area of the city is not considered an area of high crime. The applicant has passed the required background check, and the proposed security measures have been found to be adequate by the police department. In addition, all patients and caregivers will be required to follow membership rules, which state that no cannabis is to be consumed on site or within 1,000 feet of the dispensary, and no loitering will be allowed within 200 feet. Violation of these rules will result in the patient or the caregiver being prohibited from entering the dispensary again. This project complies with Chapter 2880 of the Santa Barbara zoning ordinance. Therefore, staff recommends that the staff hearing officer approve this application for a medical cannabis dispensary, make the findings outlined in the staff report, and subject to the conditions of approval in Exhibit A. We have received some correspondence from some interested parties, which has been forwarded to you as part of the record.
Okay, great. Thank you. If you'd like to state your name and add any other...
John Donahue. I thought I would just do a quick overview of how the operation works, just so it's clear. The patients members will come into the private parking lot, where they will then enter through the entrance into the reception area where there is a state-certified security officer. The reception area will then take their verification, will take their recommendation, verify it through the doctor. Then the patient will go through into the secured dispensing room, receive their medication, then they will go back out through the lobby, back out through the door. At no time will anybody not be on camera or be watched. There are 3 monitoring systems. There's one inside the dispensing area, there's one at the state security officer, and there's one at the reception desk. And no loitering will be allowed in the parking lot. If somebody brings someone drives them or is tagging along, there will be no one allowed to stay in the parking lot. They all have to come into the lobby. Is one of the requirements that we also have.
So if they're not a patient, they're going to go in
If they're
the
not
lobby?
a patient, they can still come into the lobby area. They cannot go into the dispensing area. Just so there's no loitering in the parking lot as well.
Now, how are you going to, there's a lot of doors. There's 1, 2, 3, 4. How are you going to secure them?
The front door and the dispensing door both have electrical buzzers that will be controlled by the security officer or the dispensing room. The back dispensing room door has a emergency exit, fire exit, but it has a cage door on it, so it's not an enter or exit. It's not going to be used unless there's a fire. Same with the back door here. The windows have the bars on the inside of the dispensing room, and this whole area is controlled by the security officer. Plus, we are also going to have routine checks of 200 feet of the dispensing area of the dispensary in the neighborhood to make sure there's no loitering.
Okay, your operational plan doesn't say that. It just says it's going to be surveillance via the video. It doesn't talk about patrolling the area.
We have
So
two.
you are proposing to patrol the area?
We are proposing to patrol the area with a staff member. Also, we are prepared to have our security, the company that we're hiring, is going to be doing routine sweeps of the area as well.
And how often?
On an hourly basis.
Ms. Reardon? As a clarification, the applicant did provide this clarification letter, and they have demonstrated here that they propose to have an additional or state licensed security guard on premise to help with patrolling the outside of the dispensary and control loitering. So I think it says non-state, but
Yeah, no, it
But
will
the
not be.
condition, well, but the conditions of approval that are that it is a state, though.
yeah,
Oh, is it?
That any security hired would be.
that's how
they've
they've required that for previous dispensaries. So we
Okay.
want to stay consistent.
So you're saying hourly patrol?
Hourly patrols, yes.
Is there any other comments you'd like to add at this time?
I think that's about it.
Okay. Did you want to ask
Ms.
Tim?
Reardon, I had a question about the rear entrance.
Go ahead.
I guess the westerly entrance, not that one, the other one. That one is a it's a required handicap accessible entrance, and I'm not sure that's allowed to just be an exit door. I'm pretty sure that it's not allowed to just be an exit door. That has to be accessible to handicapped people who park in that parking space. And so maybe you'll have to change.
Maybe I phrased that incorrectly. This is the door that I was referring to. I'm sorry.
Okay.
This is the handicap entrance because this is the handicap spot for the parking.
And how will you control access through that door?
There will be somebody that's in the parking lot that's doing the monitoring that we just discussed. They will be able to inform the security guard at the lobby to let him know that somebody's coming in the back door, and then the security officer can then supervise the entrance of someone coming in the back door.
So are you proposing to have someone placed back in the parking lot the whole time?
Well,
Is that what you're just saying?
yes, with the option to be able to, if there's no one in the parking lot, they can still keep an eye on making sure that no one's loitering around the front area. Are you saying having someone positioned in the parking lot at all times?
Well, no, yeah, that's what I was questioning, because you had just said if the person back here sees the handicapped person, they will let people know.
Yes.
So then that's why I asked the question if someone's proposing to be stationed here the whole time.
Because how will you know if a handicapped person drives up or not?
I didn't say, but then yes, I guess we will have to have somebody monitoring that spot. With the camera system and everything, we thought that would be enough to see if somebody was coming and parking into the area, because we have a camera that covers this whole parking lot, and then we have 2 that go this way, and this one that points that way. So we technically have 4 cameras covering just the parking lot.
Mr. Reardon, I'm not sure, from site visits with the Building and Safety Division in previous or in other dispensary applications, I'm not sure that that is going to be adequate. I think there has, and unfortunately our Building and Safety rep is not available right now. What they told me last time were in another. Actually, you know what? Maybe that's changed. What I was about to say is, I didn't think that the Title 24, the handicap accessibility requirements, would allow not full access. You know what I mean? But I'm not sure about that right now. Now that I'm thinking about that a little bit more.
Is there someone you can go ask while we open the public hearing?
Yeah, I guess Ms. Broderson's going to go ask.
Okay. All right, well, we'll get back to that because I do have some questions related to that. I was just thinking I would hear from the public and then ask the questions so we can figure that out. All right. Is that all? Did you want to add something else? Or?
Yeah, I think we're good.
Okay, great. Thank you. I'd like to open the public hearing. I do have a number of public speaker slips. I would request that you try to limit your comments to 2 minutes. That would be appreciated. The first person I have here on the list is Robert Fedor. If you'd like to come up, followed by Sharon Barn. Right.
Burr.
If you'd like to come up and have a seat in the front, so then you'll be ready to talk. Thank you.
Hi, I'm Robert Fedor. I'm here to talk about my disappointment. I'm with Advantage Planning. I'm here actually representing myself, not my client today, with the criteria for issuance of a dispensary permit, Section B, number 3. I've brought this up to the Ordinance Committee. My understanding is that this is going to be addressed. It's for those applicants operating other dispensaries within the city that there have not been significant numbers of calls for police service crimes or arrests in the area or to the applicant's existing location. That's a little constrictive. I think that in a use that's as sensitive as this, that somebody that's operated a dispensary in the past, which they've indicated that they've operated 4 successful dispensaries in Southern California. So a simple Google search, which I believe this was forwarded to you. I can give you a hard copy.
No, I have one.
Okay. Would you like an additional one? I mean, it's you're good.
Yeah.
Okay. I think that bears itself out. For convenience, I've also listed Detective Russell, officer in charge of West Valley Narcotics, as well as Marisol Espinosa, who's the legislative deputy for Councilman Zine, which is District 3. They were shut down. So, and you can go into that for yourself. I don't think I need to address that. But I think that the staff was forced to find this in their due diligence that because this applicant had not existed specifically in Santa Barbara City, that was okay, and I don't think that that's the intent, and I do believe that that's being addressed, and I wanted to bring that to your discussion, to your attention, and I hope that you guys reached out to those folks that had dealt with Aloha Spirits previously.
Okay, great, thank you. Sharon, followed by David Hughes.
David Hughes had to leave.
Oh, did he?
Yeah, so he will not be able to speak, but he submitted written comment to you, I believe, on this subject. I understand that your purview is strictly with zoning and regulations around zoning. I would like to ask that you consult with the city attorney before making a ruling on this particular dispensary. I realize that you are not, it's not your purview to look at larger state law around what dispensaries can and cannot do, but since the ordinance that you are working with was approved in March, I guess, of last year, 2 pieces of case law have come down that are in conflict with that ordinance. The first one is that primary caregivers need to do more than just provide marijuana. That under state law, that defense does not hold. So dispensaries that call themselves primary caregivers and sell marijuana are not held from liability in the state courts. That was an appeals court decision rendered in August of last year in People v. Mensch. The second piece of state law that you need to be familiar with is guidelines that were handed down by the Attorney General, Jerry Brown, in August of last year. And those guidelines state that the only legal form of organization for a dispensary would be cooperative or collective. Cooperative meaning that all profits are distributed equally among all members and it complies with state agricultural law. And collective, which there's not really a clear definition on, but basically it's people growing and consuming together when they closed loop, not a retail operation. It's Jerry Brown's opinion that retail operations have been in existence for some time in the state, but they are probably not legal. Recognizing that your ordinance was crafted before those decisions were handed down, I think it would be in your best interest. I recognize you can only deal with zoning, but I would advise to consult with the city attorney to review those pieces of case law and ensure that we're not approving a business that is perhaps illegal under state law. Thank you.
Okay, David Hughes said, ordinance criteria B1 requires the permit to be consistent with the intent of the Health and Safety Code. The State Attorney General's August 2008 guidelines for the Health and Safety Code state that an individual or corporation are not authorized to operate a commercial medical marijuana dispensary and that storefront dispensaries are not authorized by state law. The next speaker is Tony Vasello, followed by Pat Clemens.
Hi, I'm Tony Vasallo. I live in the Brinkerhoff Historic Landmark District. And one of the main points I'd like to make is that the Milpas, Haley, Chapala street corridors have basically been targeted for the location of and proliferation of the medical marijuana dispensaries. And the cumulative effect of targeting and proliferating of these dispensaries is going to have serious social and economic consequences on those street corridors. They are going to affect our whole downtown area. And for that reason, I'm here to speak about that. A number of constituents throughout the city have, through various venues, addressed this issue. And you've heard from schools, you've heard from special needs facilities and others, downtown organization people as well. In reading the ordinance 5449, it's pretty clear that your obligation as the hearing officer is to serve primarily the general welfare of the city. So in light of the decisions, which I can't follow Sharon on that, she's right on the button with those legal decisions, but in light of these recent decisions from the State Attorney General and other California law cases, this mounting evidence indicates that 5449 is inconsistent with state law. And the for-profit, for-sale storefronts are basically illegal operations. So we would request please consider continuing the matter until the legal ramifications of those decisions can be researched and placed in writing and become part of the public record. Rendering an approval on the matter without such clarification excuse me, puts you in a very compromised position of potentially exceeding the limits of your administrative authority in your zoning review of the matter. Thank you.
Great, thank you. Pat Clemens, followed by Bill Barley.
Sorry, I can't sit. I have a medical condition.
Okay, if you can hold, or can you?
Stand there. Bend down a little bit. My name's Pat Clemens. I'm a property owner at 314 East Haley Street. I've had a business there for 35 years. I'm basically, I'll give you a letter from all the tenants and property owners on that block, except for the applicants, that we are against this because this particular block is a highly mixed-use block. It's not just businesses. There are people living here, and there's children. There's children involved in the businesses that are within 25 feet of this proposed place. And so we're just asking that you consider the whole block, and that there's not one person that is for this project. And we would just recommend that you take in consideration of the children that are there all day long, and some of the children are within 5 feet. Will be sleeping within 5 feet of this place, and nobody's mentioned anything about the hours of this place. You know what the business hours are going to be?
Yeah, the recommended conditions of approval state 10 in the morning to 7 at night.
Okay. The other thing is, I think the security issue is really important. There have been, I've lived through all the problems in the 80s and early 90s down there, and I don't know why that wasn't presented in here. And I'm not saying that this business will cause that. It's just I don't think you can, even to get the police to come down when we've had an issue in our business, it takes 20 or 30 minutes to get there. So I'm not sure the police can add a whole lot of being able to respond quickly with all the other things that they have going. So security is a huge thing for us and for the kids that are there. And there's kids that they range from 1 to 15 in years. And I just want you to know that this is not just a commercial place of business. It's also people that are living above these businesses. And please take that in consideration in determining this. Thank you.
Okay, great, thank you. The last speaker slip I have is Bill Barley. If you came in late and you want to submit a speaker slip, you can go ahead and fill one out and give it to Gloria.
Thank you. I'm Bill Bailey. I'm a property owner further down on Olive Street, co-owner of a building down there. And as previous Pat Clemens mentioned, that area has been tried to be an industrial area, mixed use, etc., that we've been trying to clean up for the last 20 years. And bringing a medical or marijuana dispensary back in that area will create the same problems that we had with the old Elks Club and constant police ramifications that had to come down and respond to that. In addition, I'm not sure, there is a school, and I understand that the school is outside of 500 feet, etc., but those children do walk to the shopping center there, do walk down that street, and could be impacted that way. Also, the particular parking lot that this project has exits onto Garden Street, which is an extremely busy access road for getting into this industrial area on that, and will create a traffic problem. And I can foresee major problems and delays in traffic, etc. We're trying to clean up the area, and this is not the business that should be in this particular area to represent our city. Thank you.
Sure, thank you. Okay, I don't have any other speaker slips. As Mr. Otteson said, I have received some letters regarding this project. One from Paula Kinnison in opposition to the project. Another one from Steve Campbell in opposition of the project. And then a packet of information from Tony, who spoke earlier, Tony Fasello. Robert Fedor, who spoke early. This is all just the supporting documentation. So those are the ones I've received. Was there other ones? No? Okay, then I'd close the public hearing.
Ms. Reardon, did you receive 2 letters? I just got them this morning.
Yeah, this is
okay.
Stephen. Mr. Cotta, I don't know if you wanted to respond to any of the public comment in regards to the crime and the provision of the ordinance about, what was it, B2 or B3?
Yes, thank you. We did ask Captain Martel to attend the meeting and was not able to attend, but he did respond to an email that I sent, and on September 15th, the first time we had a presentation on this subject, the ordinance, to the ordinance committee, he did present crime statistics, and he provided the top 10 of Part 1 crimes, which are violent crimes. And he said then, and he reiterated in an email to me, that reporting district 43, which is the district that this applicant is in, is not in the top 10 of the Part 1 crimes. Also, he says anecdotally they haven't seen that area as a specific high crime area for Part 1 crimes in the last couple of years. He says there are alcohol type offenses, DUI, public drunkenness, and urinating in public, that sort of thing. But not the. But he definitely does not consider it a high crime area. Now, another thing I wanted to respond to was the request for continuance. I did get that request from Mr. Fasalo yesterday and the day before, or the last couple of days. I did speak to the city attorney, and the city attorney's direction to us was to proceed under the current ordinance. There's been no moratorium from the city. From the city council. The city attorney's office is well aware of this legislation or the case law that has gone through, and so they're aware of that, given their direction to us, and gave their direction to us.
Now, what about the comment that was brought up regarding the storefront locations versus the collective model? I know Mr. Francisco on the ordinance committee requested that to go before the full council soon.
That's correct. That is tentatively scheduled. Councilmember Francisco and Councilmember Falcone asked for that discussion of what we'll call dispensary model versus the collective model to be discussed by the council. That's tentatively scheduled for 6 p.m. on November 17th.
Okay.
Which is basically 2 weeks from yesterday. And we'll get I believe from my attendance at the ordinance committee meetings, I believe that the purpose of that will be for the city council to discuss how does the city want to wrap its hands around this issue of medical marijuana. Not up until now, but the current ordinance that we have has taken a land use zoning model. Right. And the question is that enough, or does the city want to expand that into a full-blown enforcement of Proposition 215 and Senate Bill 420? On the issue of dispensaries and collectives, the State Attorney General's opinion does say that a storefront dispensary for a collective may be legal, but definitely retail sales are not legal. And the whole thing about the caregiver, I think that is definitely true. Supreme Court, California State Supreme Court ruling on that. I think a lot of the dispensaries have turned into collective or are stating that they are collectives. And maybe you can ask the applicant about how that would work in this context. The last issue was the issue of I think it was B3, the fact that there have been no calls for service on other dispensaries in the city. Given the city attorney's direction that we have the ordinance and we have to abide, you have to approve or process the application versus under the current ordinance, there is no requirement that we look to other jurisdictions. No. If you do want to, I have a little bit of history about we did do a little bit of research on Aloha down in LA, and I could give you a little bit of that, what I know about that if you would like. Okay, Captain Martell contacted his contacts in I think it was the district attorney's office. I can't remember exactly, and the question was, was this dispensary, particularly heinous, I guess, in terms of their operation, and why were they one of the first ones to be, I wouldn't say prosecuted exactly, but what happened was and I hope I have this right, the City of Los Angeles adopted an ordinance that had a hardship provision, and the Aloha applicants submitted a hardship application and opened their dispensary. And then And then theirs was one of the first hardship exemptions to be heard by the council or whoever hears them. I can't remember. I don't know who exactly. And they were turned down, and then zoning enforcement down in City of LA shut them down. There was nothing particularly heinous about their operation and there's no reason that they were chosen to be one of the first ones, as may have been alleged by somebody. And I speculate that they were just alphabetically one of the first ones because their name is Aloha. But there wasn't anything special. What Captain Martel reported to me, it was nothing special about why they were first.
Mm-hmm. Okay. Great, thank you. Okay, I've reviewed your operational plan and security plan and response, and I actually have some questions that I would like you to elaborate on. One we touched on was regarding the security plan. Reading the application submittal requirements, like I said, didn't mention anything about patrolling the area. It just talked about watching a closed-circuit TV, and I wasn't clear on how you're proposing to provide the security, but I think we discussed that. The other one was in regards to the multiple doors, and how to secure the multiple doors in regards to security, and then also what is required by ADA.
Chris Hansen had to go to a meeting at 10, and there's nobody else that is familiar with this particular DART case.
But is there someone who can discuss just ADA requirements? Looking at the plan, to me, trying to figure out how you're going to secure the entrance, and I guess it comes down to what we have in a lot of these instances is a matter of trust. The ordinance requires the entrances to the facility to be clearly visible from the public street. This door here is not clearly visible from the public street. There's a large structure, stairway that you can't see that door. You've stated that it's going to be locked during operating hours, but who's to say a year from now that it's, it would be good to have people come in and then just leave out the back door to the parking lot. So how are we going to ensure that this is not going to be used? Remove the door, put a window instead?
No, I'm not sure that would fit the fire code for emergency exit.
It's one unit. It's one building, so you have entrance here and exit here.
If that would be something that you guys would like to be done, we have no problem with doing that. Just as to explain why no one would be able to come in through that door would be for our own safety. If someone opens that door, then anybody in the parking lot can come running right through that door. So for our own personal safety, we make sure that everyone has to go through. We aren't even going to go in and out that back door. If we go out the back door at all, it'll be this door. It won't be that door. Just pure and simple safety.
Mm-hmm. Mr. Reardon, could I ask a clarifying question? I thought you said that door was only going to have emergency exit only, right? So it's one of those
panic doors. It will be used only as emergency exit only. We can still go in it if we wanted to from the back, but there's no need to use it. But if we have to have it as an emergency exit, we're prepared to.
We spoke with Chris Hansen this morning, and he said that door is not required. So it could be blocked off, or it could be, they have some hardware that if you open the door, then the alarm goes off. You've seen these things, and that might be adequate. I don't know.
If I may add, in our alarm system, I think I threw a little note to you. Every window and every door is alarmed, and it notifies you over a speaker which door is open, where the back door is open, office door is open. So every door has an alarm on it already, as a criteria of our own safety as well.
Mm-hmm.
So if that helps,
we know. Okay, the other issue, or the other concern I have, and I had a similar concern on the dispensary on 2 West Mission Street with the recessed door and the visibility along the street front. And can you explain your thoughts why a recessed door versus, I noticed there's gates here right now. I don't know if they've been permitted or not, but it seems to me if there's a gate here now, why can't this be a door? And for access to have just the one entrance, and then extend however you need to do it, and just have this be the lobby and come in here, so there's just the one door from the front.
When the city came out, when you guys came out to look at the property, I believe it was a requirement as a handicap access to go in that way. I'm not sure if it blocks it for the door there, but I know that for the ramp, the concern was the ramp was a certain degree, and they were concerned it had to be a certain degree, otherwise it would cut into the sidewalk. So I believe it was a handicap issue as why there's no door there. The gates that are there now are just as a security measure when the building is closed.
Well, with Milpas Street, what they had other options they can do. They were going to look at either relocating the door along the face of the building or building up the sidewalk area to bring it up to the grade of the inside of the building. Was there other options that were?
If you guys propose you'd like us to turn that into a front door, I don't see a problem with it. I would think it would have to be something cleared with the building people to make sure that it's not a blocking of a handicap access of any kind. I know that they were discussing it, and it should have been, they needed something in writing or something saying that the ramp was...
In reviewing the floor plan and the security with the building and safety, Chris Hansen, he stated that was required for ADA accessible, and there's no other option for an ADA accessible pathway to get into the building. This is okay for a secondary. This is the only. Yeah, I don't understand why that's ADA. Why they have to have 2.
Ms. Jordan. So according to the Building Safety Division, the front door has to be handicap accessible. It's not the main entrance for the handicap parking space. That has to be through the closest door. But nevertheless, it does have to be handicap accessible. And there is about an 8 to 10 inch grade differential between the sidewalk and the finished floor, as I understand it, of these ground floor units. And so the ramp, so this area here is actually ramped upwards from the street. There used to be a step before the building was remodeled, and as part of the previous remodel of the building, handicap accessibility was required. So this is turned into a ramp that ramps up to this line here, and then that's a level spot. And so I asked the question because at 2 West Mission we said it was possible to raise the grade out on the sidewalk, and his opinion about that was just that was 1 or 2 inches, where this is 8 or 10, and he didn't think that it would be really feasible to have that much ramping in the sidewalk.
But what would be the difference? The ramp still occurs. The door's here. The ramp's still inside the building now. Instead of this is the access to the building. What would be the difference having a door here and it ramping up?
My understanding is that on either side of a door there has to be 5 feet of flat area, the landing. And if you put 5 feet here, there's not enough rise or run for that required rise. You know what I mean? If you had a 5 foot flat area that would go back here, and then you'd have to have the 8 inches of rise in like 2 feet. That's not an adequate ramp.
Or reconfigure it so it ramps inside. I mean, the way it is right here, that wouldn't work. But this could be redesigned to provide the ramp inside the building.
That's true.
And have a flush face.
That's true. I suppose the issue is that this is these are potential tenants to the building, and the building when it went through its remodel, this tenant not being anticipated, this is what works from a standard.
When there's two separate.
Yeah, correct. And normally for a normal storefront, there is not the alcove issue, security issue. So yeah, a possibility is to change this whole thing around so that the ramp goes further up into the building.
I saw you raised your hand.
I have a suggestion. These outer gates.
Could I add something to that? My name is David Back. I own the building.
He's the building owner. He's the one. He knows more about what we're talking about here. If that would be okay.
Okay. What's your name?
David.
Spell it, or David, but spell your last name.
David, last name Back, B-A-C-K.
Okay. Yes.
Okay, in regard to that entrance, it's easier to see this. Okay, all this requirement here. Which we use Dale, what's his name?
Dale, a fine line.
Joe Campanelli, they're the ones that basically designed this building. They have lengthy conversation with this, whatever department that is, as far as coming with a solution for the entrance for this building, in order to meet all the guidelines that the city requires for ADA approval.
See, are you on the mic? Okay.
So it comes to surprise to me that we're talking about, it's easier for you guys to think about moving this wall. It's not possible. All the plumbing comes through this wall. And all these conversations, especially for the ADA, was expressed in lengthy hours dealing with the city back and forth. So I could almost say that it was required by the city for us to comply with this particular design.
For the two tenant spaces, if there was one big room, there might have been another option you could have done if it was proposed as one tenant.
I don't see what the difference is between having two tenants.
What you're proposing right now is one tenant to fill these two spaces.
Mm-hmm.
Okay, so if you were proposing as part of your remodel just to have one tenant here, the solution could have been different. But the fact that you were proposing to have two different tenants here, the solution that was come up based on that floor plan is this solution.
So would you say that if we close this door and we make it only one tenant, then we wouldn't be having this conversation?
No, my concern is with the recessed door and the proposed use of the medical cannabis dispensary, and having a recessed door and security of that area and visibility from the street, having an entrance from a public street that is clearly visible, and this is recessed back here. So my comment was, how can we have the front door be flush around the street and still meet ADA requirements? And what I'm saying is that at the time that the remodel occurred, if this was proposed one room, one tenant, not two separate tenants, there might have been another option that was looked at that didn't entail the setup.
I don't see the relation. If any other business were moving in, you still need ADA.
Correct.
So that conversation, it only applies because of the type of business that they're running?
Yes.
I see. Okay. That changes the whole picture then. But anyway, as far as my understanding is concerned, we're complying with everything that the city had required at that point, at that time.
For just a tenant improvement with no designated tenant, it's just a TI permit.
So I can, yeah. So I wouldn't be able to tell the difference between a handicapped person going to a business such as his or...
Correct. You still need to meet ADA requirements. You're right.
So the ADA requirements are not met here?
It is met here.
Not for our...
Not for your particular
us.
business.
Right.
Okay.
Because what my concern, I can't do anything that makes... I can't approve something that's... My approval... You still need to provide ADA accessibility.
Correct.
So if I were to say, oh yeah, okay, I'm going to approve this, but this needs to be flushed, what you would need to do is figure out how to meet the ADA requirements, whether that means changing the slope in here, changing wall locations. The fact that this would be flush with the front face of the wall would then not negate the need to provide ADA access. Does that make sense, what I'm trying to say?
It wasn't to me, but you guys know the language.
Because that's a state law, and buildings have to be accessible. And what so you need to balance all the requirements in your plan. And so what I'm looking at is in terms of our ordinance and providing visible access to the building and security for the building and the neighborhood. And with the recessed door, I have concerns with the recessed door. And that's where the whole conversation.
I have a suggestion, if I may.
Yeah.
Right here where you propose to have the door is where the cage is right now. It slides in the walls and back out. What if we put in an automatic door right there to take out the cage and make it a sliding door so it's not going in the building or out on the sidewalk. It slides in and out of the walls like it does now already with the cage. Then you have a storefront door. It's still handicap accessible and it's not intruding anything.
That would be a storefront or a flush face entry. You'd need the cameras out there. It would be just like a front face.
So we would move this camera out to there? Is this camera?
You'd work with the police department.
Okay. Well, I'm just asking if that would be a viable solution.
Mr. Reardon, I would suggest that if you're inclined to approve this application, that you put a condition that the front door be flush and that they would have to work out whatever handicap accessibility and security requirements for cameras that would be necessary through building and safety and the police department.
And that's what I'm trying to say in regards to the flush building and what Mr. Cato was saying with he understood that you need a 5-foot flat area on the inside of the door.
Mm-hmm.
So if you're proposing a door here and 2 doors here, I don't know if that meets ADA. If I were to approve it and condition it, it would be this, and it would be up to you to balance all the requirements, ADA requirements, and if this configuration worked, then that would be okay. If not, and you need to do other changes to the building, then that would be different. But my concern is with the recessed entrance and the visibility of people in that area. I know there's a camera there, but still.
Mm-hmm. To be able to see it from the street.
Yeah.
Where's the camera? Here and here.
Cameras everywhere.
In regards to other packaging, can you explain how because you are proposing, what kind of things are you proposing to sell here?
The flowers and the food. The edible, as a list, brownies, cookies,
Right, okay. And how would they be packaged?
Each individual food item is labeled and is packaged and sealed and labeled with all the ingredients on it and the safety code on it, the 11362. The flowers are put into a container, then put into a bag that is then sealed, stapled, so that, and then people have already signed off knowing that they can't open it within 1,000 feet of the club.
Now, is there a note on the outside of the bag reminding them of that too?
Yes, do not open until home.
And in your, go ahead.
There's also a label on every container and every food item before it's put in the bag. So it's itemized 3 times.
Mm-hmm. On your application stuff where it talks about the ordinance requirement is no dispensary shall sell or display any drug paraphernalia or any implement that may be used to administer medical cannabis, and your response was that ASOC would not display any drug paraphernalia or any implement that may be used to administer cannabis. So you're saying you're just not going to display it, or you're not going to sell it?
We're not going to sell it.
Okay, so or provide it?
Or provide it in any way.
Now, when you talk about in regards to security and all that kind of stuff, you state that you'll take all reasonable steps to discourage and correct objectionable conditions. Can you kind of explain what you mean by that?
Any patient that ever shows any disregard for the rules, or the membership rules that they've signed, as far as bringing somebody to the parking lot or opening the bag when they leave or doing anything that is breaking the rules, they're subject to, usually, if it's depending on the offense, if it's like they left somebody in the car, we have someone now that's watching them. We would give them a warning, but as far as opening the bags or doing anything against the membership rules, they're immediate dismissal. They're not allowed back.
Mm-hmm. Okay, I think those are all my questions. I'm going to make sure those are all my questions. Okay, yeah, those are my questions. Okay, now explain again your security for, okay, this door, you said you'd be open to remove it and put a window.
Yes.
Flush up here. Now, how are you going to I control access here? Okay, so explain again. So coming in here, you have to buzz to get in. You go through the medical detector.
Mm-hmm.
So you do the same thing here. You buzz to get in.
Mm-hmm. No, we wouldn't buzz to get in because someone would have to physically go back there and make sure that they're watching that door, because that door, well, I guess it doesn't really affect us, and it would be this one. From what we were just discussing, I thought we proposed that we would have another security guard in the back that's watching the area that would let this person know, or so that you have the security guard come here when someone's coming through the back door.
And that's what you're proposing, is that have someone in the back parking lot.
And if we do have someone in the back, it has to be a state certified. Is that what you were telling me before? So just doing hourly patrols, you don't think would be enough?
Well, what I'm asking you is, how are you going to secure this doorway? Hourly patrol, yeah, that patrols the area. It would discourage loitering. It would just keep an eye out on the streets in addition to the camera.
Mm-hmm.
Since you don't know when someone's going to show up, that's going to need access to this door.
How? That's where I'm confused. Is how would we not know someone showed up?
Because this is your main entrance, and you have your office up in this area. You have a dispensary over here. There's not. That's how.
Are you saying that you would see from the cameras?
Well, yeah, I'm sorry. That's what I'm trying to say. Is that with this camera angle, this camera angle, this camera angle, and that camera angle, with the security guard observing the surveillance system at all times, I don't know how someone would be able to get in the parking lot without us knowing.
Mm-hmm.
But we're prepared to do whatever it is that makes you feel comfortable.
Okay, and then what? I guess I'm not being clear. So when you see someone come into the parking lot wanting access here, someone would get up and would open the door?
Yes.
Okay. And that answers the question.
That we would have a doorbell there or something. Or,
mm-hmm.
Yeah.
Okay. Oh, here's Mr. Hanson. Let's see here. Do we? Yeah. What the questions? You put that over there. With ADA is just trying to get straight. Do you know a lot about the ordinance about security plans and cameras and having controlled entrances and...
Not in specific detail, no.
Okay. Well, they need to have access to the facility that's off of public. The main entrance needs to be off of public street, clearly visible, free of obstructions. And my concern, and I had a similar concern on 2 West Mission too, was with a recessed doorway and the visibility of the front entrance from the street. And in the case of the 2 West Mission Street, I required the door to be flush with the face of the building, and Mr. Garcia was explaining there was other options in that instance, raising the sidewalk. I don't remember what the difference was between the sidewalk and the inside of the building. I don't remember. But raising the sidewalk, or in that instance they could move the door location. I realize the existing facade of this building doesn't lend itself to moving the door. So it seems in this instance the option would be to have this be flush. And so I was questioning, Mr. Cato was saying, you can't have the doors open to public right of way.
Correct.
So they need to go in. So you need to have at least a 5-foot, what Mr. Cato was saying, a 5-foot flat space, and then maybe ramp up. I mean, is there truly no other options than having it recessed? What the applicant was suggesting is possibly having, there is a gate right here, but making it more of a door, a sliding door, and then allowing this, still have this kind of configuration with the ramp here.
The requirement would be that there be an accessible path of travel, and if you don't use an elevator, then you have to use a ramp. Whether it's an exterior or an interior ramp is the choice of the applicant and, or in this case, Public Works. They probably would not want a ramp on the sidewalk there because we're looking at, I believe, 7 to 8 inches of height difference between the interior finished floor elevation and the sidewalk here. That said, there's no reason why you couldn't come into a door and then ramp on the inside parallel to the front wall. That was not an option. This is a raised floor building, so it would be a lot of construction for the foundation and the floor work there. So this was the option that was decided on. Of course, this was originally 2 separate envisioned as 2 separate commercial units. You would come up the ramp and then you would be able to turn to go into either of these entrances. The requirement is that you have accessible path of travel from the public right-of-way, the sidewalk, and from the accessible parking. So you really, in this instance, have 2 separate accessible entrances that are required. And that was because this building underwent such a vast and huge remodel. It was almost basically a brand new building, and their cost of the project was that. So this was originally designed not with the security and not with the medical marijuana type of operation envisioned here, which was the reason for the alcove.
Okay, so that does go to my comment earlier when I said if this was originally envisioned to be 1 tenant space, the solution probably would have been different than this.
Correct.
So the reason why this is the way it is now is because it was originally envisioned to be 2 separate.
Yes, it was intended to be 2 separate. I don't believe this door is there. It might have been put in post, but originally, these were 2 separate tenants. That's why you have, they're basically bookmarked individual units, mirror images, so to speak, and 2 separate entrances off of the parking lot, both of which are available to the accessible parking space, and then the accessible entrances off the public sidewalk to the front.
Okay, and then in regards to, that was another question I had, was regarding the second door, whether it's a code requirement or not, because it's not clearly visible from the street. And the applicant was stating they could make it have panic hardware and only be used in emergency. Or I question whether if it could be changed to a window. Is it, since it's 1 unit now and there is is this door required?
With it being just 1 tenant space on the bottom, this door would not be required, no.
Okay.
Because this would be considered the accessible entrance off the accessible parking space.
And this is required even though everybody else who is able-bodied would come along the sidewalk and come in this way?
That's correct.
It's not just that they can't go behind a car, it's just...
Well, you're not allowed to send the person in a wheelchair or with a crutches or a walker down a drive aisle that's parallel with the vehicles moving or behind. This is their own vehicle, so that's not as big an issue, but the main issue is the fact that this is a driveway and you're going with the direction of vehicular traffic. So it's considered a hazardous area unless you have some sort of physical separation between the pedestrians and the vehicles, bollards or something like that, which obviously you couldn't do because of the parking space.
Did you review the Chapala Loft cannabis, medical cannabis? Because they had a garage back behind there, and there was no access from the garage to the building. They had to come out. This is Chapala. They had to come out this way to get to it past Esau's, or come out. Oh, there was a walkway here.
Yeah.
That's why. Because then they can come up around and go this way. And it was separate from the trail. Okay.
Yeah, if this was a path of travel, if this was a sidewalk out to here and you had a gate here instead of that being a planter and fence, and it was 42 inches wide, then certainly that would be the accessible path of travel or something. We could certainly work with that.
Okay. I think those were my 2 questions, right?
I thought you had a question about how the security would work and accessible access through that back door. Did you get that resolved when I was out of the room?
Oh, yeah. What applicant was stating was there's cameras. Someone would be monitoring the cameras. Either the person would be stationed back here, or there'd be cameras monitoring the parking area. And when they saw a person pull into that parking space, they would come and grant them access.
Right. If everyone has to be let in by either security or has to push a button or whatever, then that would be considered equivalent facilitation, and as opposed to if it was only the person in a wheelchair or crutches or a walker.
It is only the person in the wheelchair and the crutches.
That would not necessarily be considered. I mean, if an able-bodied person parked here and they were able to come in here and open the door and go in without having anyone from the inside open it up, but you made someone that was in a wheelchair ring a bell or something, that would not be considered.
No, this access would be restricted to disabled only. So able-bodied people would have to walk around to come in this way. Is that not okay?
Well, there isn't necessarily any rights for an able-bodied person to be able to use the accessible only entrance, like there is the accessible person having the right to be able to use the same entrance as everybody else.
So if this was signed and marked handicap or disabled access only, that wouldn't violate anything?
No, because it's also the direct and most close path to travel from their accessible parking space, so that would be preferred, which is a code requirement, that it be as close as possible. And then the buzzer or the manner of method that they get the attention of people on the inside would have to be such that, it's a nice big flat button that you wouldn't have to grasp, pinch, pull, have special knowledge. The sign would have to also be in Braille and those kinds of accessibility items, but that certainly would be a viable solution. And the able-bodied people are able. There's no disallowance for them not to be able to walk down the driveway. It's strictly the people that are not able-bodied, that are in a wheelchair or have crutches or walkers or those types of things that they're not. You can't require them to walk down a drive aisle.
Okay. I think that answers the ADA. Thank you.
You're welcome.
You were pretty popular. It kept going out there. Seemed you were back.
Must have had a buzzer when I walked in.
The radar. All right, so then I was just going down the criteria for issuing the dispensary permit. Crime area. So we covered 2 and 3. 2 was not identified by a high crime area. 3 was for applicants operating other dispensaries within the city. Fees, size. I know another discussion that has been vetted before the ordinance committee has to do with it relates to 6, I think 6, 7, and 8, that the issuance of the permit would serve the needs of the city residents within proximity to this location. And then I know the ordinance committee has discussed also putting a cap on the number of dispensaries within the city, and also limiting, so cap, they've said 4, they've said 7. I don't know that there's been a particular number identified, but I know that there has been, they've talked about breaking the city up into different regions, the Milpas, East and West State, Upper State, and I know I have an existing ordinance that I'm reviewing your application under, but I think I can use what they've been discussing as guidance in determining whether this facility would cause or would be an overconcentration of facilities in a particular area. And I've looked at a couple existing maps, that adopted maps by the city, like the general plan map that breaks the city into 32.
There are 4 different areas? Yes.
No, this one breaks it into 32 different areas to see if this facility falls within the same general plan neighborhood as the Olive Street one, which is the closest dispensary to this facility. And that one has been approved. It's not operating yet. And then also to see, I think this map has. So here is the proposed facility for people on the camera, right here on the corner of Garden and Haley. And then here is an approved one over on Olive Street. It's not open yet. So it's 2 blocks over and 2 blocks up. It's actually in a separate general plan neighborhood. And then here's a 331 North Milpas, which is opened and operating, and 500 North Milpas, which this is oh, it's approved. It's a different color green. Yeah. So this facility is 1, 2, 3, 4, 5, 6 blocks from this one, 6 blocks and 1 block down from this one. So trying to make the determination of whether the approval of this one would cause a concentration in areas. And I know, Mr. Cato, you've been working on maps in advance of the ordinance committee meeting with areas. I don't know if you can provide any other insight on that required criteria.
Mr. The ordinance committee direction to the city attorney was, and to me actually, for mapping purposes, was to break the city up into 7 different areas: Upper State, Del Lavina, downtown Mission, downtown East, downtown West, Milpas, and Mesa. That's the 7. And in my preliminary mapping, well, there's no way that this would be in the Milpas area. This would be in the downtown East area, as would the Olive Street, the approved Olive Street dispensary. There's really no way that could be in Milpas either. It just geographically doesn't work. So, and these are about 1,200 feet apart as the crow flies, more like 1,900 apart if you actually had to go by streets. And so the question is that in your opinion an overconcentration? I don't think it's appropriate to loop in the 2 Milpas Street dispensaries, because they are quite a ways away. We're talking 3,000 to 3,500 feet away, which is quite a ways. I would be highly uncomfortable saying that that's an overconcentration that far apart. Even all of our discussions about how far these things should be from schools and such, it hasn't been more than about 1,700 feet. So I would not recommend that you count the Milpas Street when you're talking about overconcentration, but the Olive Street one is it's within 1,200 feet.
Okay.
And they would be in the same area under the proposed ordinance. I mean that's how the mapping is going to go anyway, to start with.
Now, the direction the ordinance committee gave was to the city attorney to draft an ordinance, and then that draft ordinance would go back to the ordinance committee, and then to the planning commission, back to the ordinance committee, then to the council, right? It's still early in this phases?
It's quite early, yeah. We're tentatively scheduled to go back to ordinance committee on November 24th, and I'm not sure exactly what the path will be after that because of the discussion that's happening on the 17th. So it could go back to, or it could go, depending on what happens at the 17th, if the council were to say, keep going with the way we're going, then it very well might be that the next step after ordinance committee for the ordinance would be planning commission and back to council. If they chose a different path, then I think everything after the 24th would be up in the air.
Yeah. But staying the course we're on, that would be the route that the draft ordinance would take.
Yes, the draft ordinance would be, that's correct.
And any dispensary that was, you would, maybe we don't know. I was thinking like the Milpas ones, they're both in the same district. What would happen with non-conforming ones would be...
We're not exactly sure yet.
Yeah, that's way too, okay.
Yeah.
All right, thank you. I guess it's number 10 that I'm talking about, that the dispensary would not adversely affect the health, peace, or safety of persons living or working in the surrounding area, overly burden a specific neighborhood, or contribute to a public nuisance, or that the dispensary would generally not result in repeated nuisance activities, including disturbances of the peace, illegal drug activity, cannabis use in public, harassment of passerbys, excessive loitering, illegal parking, excessive loud noises, especially late at night or early in the morning hours, lewd conduct, or police detentions or arrests. So in looking at this criteria, that's why I was looking at the general plan map, because that's an existing map, although it has more than 7 areas on it. The other thing I just thought of in regards to this finding is the comment that was made at the public hearing regarding children in the area. And I know when this ordinance was originally adopted, there was quite a bit of discussion about operational parameters and the distance of these types of uses from residential uses, because as it was adopted, it's from schools, parks, and other dispensaries. There's a 500-foot radius, and there was also discussion of separation between residential zones and residential uses, and both of those were taken out of the adopted ordinance. And we ran into this issue also on the Chapala 1 project, the medical cannabis dispensary there, regarding the mixed-use building, and the discussions that the ordinance committee had in regards to mixed-use building, which this property is actually a mixed-use building and it's a mixed-use area, is that they had concerns with existing mixed-use condo projects, and that the owners of those condominium projects, when they moved in, didn't have knowledge that this type of use could be proposed in that area, and they felt different in regards to rental mixed-use buildings. And so in this instance, where those units above this proposed dispensary, they're rental, so any changes to the ordinance would not affect that. In regards to being adjacent to residential uses, that was discussed and it wasn't put in the ordinance, so that's not a criteria here. So I'm thinking with these, this is a hard situation in that, I'm reviewing this application under the existing ordinance and also with knowledge of proposed amendments by the ordinance committee. But my charge here is to review your application against what is adopted right now. And I am trying to take into consideration the comments that we've heard at the ordinance committee, but it's although they have made some recommendations, for a drafting of an ordinance, that's still real early in the process, and that draft ordinance, the language hasn't been developed, it hasn't been put before the public in a public forum and to discuss and to deliberate and to actually come up with your revised amendments. So I understand everyone's concerns regarding these dispensaries, but my role in the process is to review your application against the current adopted ordinance. And I think what you've proposed with the clarifications today, it does meet the criteria for issuance of the dispensary permit. But I do think it needs some changes to the floor plan, which I think we could accomplish through conditions of approval. And those are the ones we've discussed, that the front door be flush with the face of the building. So there's one access. That would mean that this needs to be reconfigured. Well, it may or may not, so that you have the lobby area still separate from the dispensary. And I'll leave it to work with Mr. Cato in the building department to make sure you're still in conformance with the ADA. But in terms of my zoning regulations and the ordinance, this building, this front face needs to be flush with the face of the building, and then the adequate security cameras or screening per the police department for the revised facade. In regards to the rear entry here, I would like this door removed and a window placed there. Just, it's not necessary for code. I have concerns with the and I understand you have safety issues too, so you won't want people coming free form in there. But in terms of the ordinance with having clear visibility from a public street, I think that this needs to be altered. In regards to
can I touch on that? You want this to become a window with clear visibility through it?
No, barred. It'd be barred like
okay,
this
so
one.
it can. Okay.
No.
Okay.
My concern with having the door there is that the door, access to the door, is not clearly visible from the street, and so I would prefer that this be changed to a window. This could remain the door, but I would like it signed that it's for handicap access only, and whatever access provisions that's required by ADA. If you are required to have a push button and all that kind of stuff, that's not going to prohibit that. But this entrance point here and exit is only for ADA access for disabled people. Able-bodied people need come in your main entrance. I don't think that it's necessary to have a security guard stationed back in this area.
That'd be great.
But I do want to. I don't want to cough or anything. I do want to specify. I think I'll just put in the conditions instead of revising this, that make it clear that the security guard is going to patrol the area on a minimum of an hourly basis, because based on the stuff I received, and I did receive that one addendum later, it wasn't clear that was going to happen. To me, when I read this, I thought it sounded like someone was just going to be sitting in the office watching the TV and then calling if necessary.
It won't be this security guard that gets up and leaves and walks the perimeter. There will be patrolled, like the security patrols.
Right, you're going to have two. One's going to be
separate
stationed
people,
here, and then the second one's going to be the one who's patrolling areas.
In a vehicle? Or do you want an actual person that's walking and guarding the parking lot?
Patrolling would be walking around.
Walking. Okay.
Yeah, it's just not someone just coming by every hour and just driving. Oh, looks good. No, they need to be physically spending some time walking around.
Okay.
Yes, no recessed front door. And I also want to put a condition, since it's not clear in the, since the one statement in your operational plan talks about just no display of their drug paraphernalia, and some of the information that was submitted by the public, it states that drug paraphernalia has been offered to people. You know, buy so much, you get this free. That's not okay. So I want to put a condition of approval that is not to sell, display, or offer or provide any drug paraphernalia or other implement that may be used to administer medical cannabis. Because that would be, I know it's an ordinance requirement, but I just want to make it clear in the conditions that later can't be say, oh, I didn't realize that's what wasn't allowed. So it's clear that that type of use isn't, or component's not okay. I'm just going to look real quick through here to make sure that oh, and then the packaging, seal. No. I'd also like to put a condition, I think it's stated in here, and I know you've verbally mentioned it, about the product would be sealed, double sealed, and labeled with no consumption within on premises or with 200 feet. So it's just another condition that states that. So I think, was there any other?
I have a quick question about this door that we're going to close and turn into a window. To match the other window, I think we're going to be talking about huge construction changes. Would it be feasible to just seal that door off?
Oh, just close it in?
Just close it
Yeah.
in. I think that would be a lot easier than trying, because the windows are a lot bigger than the doorway.
Right, you know, that's fine, just to wall it off?
Yeah.
Yeah. That's,
Okay. Just as long as there's no access to it is
Yeah.
really what you're looking for.
yeah.
Okay.
So if you prefer, I can just say that it just be sealed off, that the door be removed.
Okay.
Because then you can look at a window or...
Whatever works, yeah.
So Gloria, just have it be that the door, the east, right, east rear door?
Yes.
Be removed. So yeah, so the front door flush, not recessed, packaging, security guard, signed entry. Pardon?
No display or sale.
Right.
Did you say that? Packaging.
Okay. So I make the findings outlined in the staff report that with the that the dispensary permit complies with the limitations on the permitted locations of the dispensary pursuant to the code. That the dispensary permit complies with the criteria as we amended it today, and that the dispensary permit is approved conditioned upon continued compliance with the operational requirements specified in the zoning ordinance. So the application is approved with those amended conditions, and my action is appealable to the Planning Commission within 10 calendar days. And to apply for the appeal, it's actually here at our planning counter versus over at City Hall, so just come to our planning counter. They also have oversight authority of all my actions, and if they believe this warrants additional discussion before them, they do have the ability to call this up to be heard before them, and that's that same 10-day window. And so if either of those were to occur, Ms. Broadison would contact you.
Okay.
Okay? Thank you.
Thank you.
And that
Kelly, did you need these?
That adjourns the meeting since the last item was continued to 2 weeks.